Welcome to the 4 parks of Universal Orlando Resort, featuring the new Universal Epic Universe. With spectacular hotels, we offer a week of vacation excitement. Visit universalorlando.com.
This is the Roger Stone Show, presented by Colonial Metals Group.
A man who's gone through hell, but he's kept going, and he's smart, and he's strong, and people love him. Not everybody, but people love him and respect him. Roger Stone.
Now, here's Roger Stone.
Welcome back to the Roger Stone Show here on the Red Apple Audio Network. We're joined now by David Schoen, who is a criminal defense lawyer who has focused on matters of civil liberties, civil rights, ballot access issues, and complex legal matters. He very ably represented President Donald Trump in one of the 2 bogus impeachments against him, and he joins us now on the Roger Stone Show. Counselor, welcome to the show.
Thank you very much. It's an honor to be here.
So, David, you are our go-to guest when they have complex legal issues that we're trying to parse. This past week, it seems to me that, to some extent, Special Counsel Jack Smith threw in the towel regarding the January 6th D.C.-based charges against President Trump. Earlier, the charges that he had filed in Florida in the so-called documents case were knocked out by Judge Eileen Cannon in a very strong ruling claiming that because Mr. Smith's appointment as a special counsel was unconstitutional, the charges he'd filed would be voided. That argument being that Mr. Smith had never been confirmed by the U.S. Senate to have these sweeping prosecutorial authority, that he had, there was no law providing for his position. There was no budgeting for his seemingly limitless budget. And lastly, it's clearly unconstitutional for any official in the executive branch to be unfireable by the President of the United States. That decision went to the 11th Circuit, but I gather will now become moot in view of Jack Smith's decision to withdraw his charges and resign. In D.C., however, the charges were essentially put on ice. In other words, they were dismissed, as I understand it, with prejudice, which means that they, as I understand it, I'm not an attorney, they could be revived after Donald Trump leaves office. Do I have that right?
They were dismissed without prejudice.
Pardon me.
What you said.
Yes.
Yeah.
And your view of that?
Let me address the 11th Circuit issue first. You've really raised some very hot issues here, and you're right on with all of them. In the 11th Circuit, as you said, Judge Cannon dismissed the case based on violation of the Appropriations Clause and the Appointments Clause of the Constitution surrounding Jack Smith's appointment. That case was pending before the 11th Circuit and still is. Jack Smith moved to dismiss President Trump as a defendant in that case, as an appellee in the case also, but not the other defendants and appellees. So that issue of the constitutionality of his appointment is still before the court, even though he appears to have indicated he intends to resign. One would think that the new Justice Department coming in will dismiss the entire case. Secondly, in D.C., as you correctly noted, he moved to dismiss the D.C. prosecution, the January 6th events in front of Judge Chutkan. He moved to dismiss that without prejudice. Now, both dismissals, both motions to dismiss, were with the consent of President Trump's lawyers being without prejudice. And that surprised me. Again, with all due respect to them, I would not have consented to that. Jack Smith was required to file a motion to dismiss in both cases. There's a October 16, 2000 memorandum from the Office of Legal Counsel in the Justice Department that's absolutely 100% binding on the Department of Justice with respect to federal prosecutions. And that says that, in essence, it piggybacks on the 1973 memo, and it says, in essence, that you cannot bring an indictment or even continue a criminal process against the sitting president. One would argue that it applies in full force to a president-elect as well, based on the principles in the Presidential Transition Act. And so Jack Smith had no choice. He had to dismiss the charges. Some people have suggested, well, he could hold them in abeyance during the presidency. But even he rejected that. And the memo makes quite clear that that's not appropriate either, for a number of reasons that are enumerated in the memo. The stigma that attaches to the president, and the more importantly, the office of the presidency, the appearance to foreign powers that there's something hanging over the head of the institution of the presidency or the president with whom they're dealing. It's a distraction to the office, and it raises the separation of powers issue, interfering with the performance of the presidency. The reason he dismissed it without prejudice, and then I'm surprised and disappointed the lawyers agreed to that, is that his theory is the charges could be revived, not held in abeyance during the presidency, but revived and brought anew after President Trump's term is finished 4 years from January. So that's a very dangerous situation. He gets that idea from footnotes 33 to 35 in the 2000 memo, which suggests that there could be a tolling of the statute of limitations so that it would stop right now, and then he would bring it again as if he were bringing it right now, but he would bring it 4 years from now without, in his view, a statute of limitations problem. These folks have shown just how vicious and politically motivated they are. I don't think you can take that kind of chance. So in my view, what should have been done is consent to the motion to dismiss. Smith had to file it under any circumstances, but reserve the right to argue that it should be with prejudice, meaning the charges cannot be brought again, because I believe you're left with the same scenario that the Justice Department said cannot occur, and that's charges hanging over the institution of the presidency. They must be dismissed, and especially in a case like this, where they've been completely politically motivated.
Now, there was also some developments in the Georgia case against Donald Trump and others that grows out of the aftermath of the 2020 election. I saw the headlines, but I confess to you I didn't get a chance to really focus on. What is the status there?
Well, there's a hearing coming up about the status of Fani Willis, the district attorney, and her conflicts of interest, whether she must be dismissed from the case and so on. But again, I say with respect to that case, the entire case must be dismissed for the same principles underlying the Department of Justice memo. It's true, the Department of Justice memo is only binding on the federal Department of Justice. But those same principles, separation of powers and the stigma that it causes and so on, all of those principles apply in full force to the state prosecution. I would also suggest that the supremacy clause is relevant here, and that is we don't allow a state, this is a constitutional principle, we don't allow one state to hamper the operation of the federal government. That's a principle that we see in election cases, Anderson versus Celebrezzi. We don't allow one state to have provisions in the election law with respect to a national election that would then throw the whole national election off kilter. Well, here it would be the same sort of principle, and that is we don't allow one state to interfere with the process. There's a very famous Yale Law School professor, Akhil Amar, who has written an article many years ago, I think during the Clinton era, in which he made this case that the states must not be permitted to pursue criminal indictment or criminal process against a sitting president for the same reasons in the federal memo. And he also says, he gives the example of a southern state that perhaps before secession in the Civil War era indicted President Lincoln, let's say. Would we really allow that state to arrest President Lincoln and tie up the entire federal government? We shouldn't. And by the way, these folks tried to do that with the Mueller investigation. And that's the pattern of all of these things, trying to stymie President Trump from his agenda that we now see has a clear mandate from the country.
Folks, if you're just tuning in, we're talking to criminal defense attorney David Schoen, who represented President Donald Trump in one of the two impeachments on the floor of the United States Senate. I want to ask him when we get back about some of the president's appointments, among other things. So whatever you do, folks, don't touch that dial because we'll be right back.
Faraday presenta Ojos con Alergia y Picazón contra el jardinero. Y el ganador es Faraday Extra Fuerte. Para aliviar la picazón de los ojos por alergia, actúa más rápido y supera a Claritin y Flonase aún a las 24 horas. Faraday, adelante.
Home means something different to everyone. But with Rocket Mortgage, home can mean even more. It can mean a college education, taming your high-interest debt, even a renovation. We've made it easier than ever to use your home equity. That home you worked so hard for, now it can work hard for you. Call 800-4ROCKET or visit rocket.com to find out more.
Rocket Mortgage, LLC, licensed in all 50 states, and MLSConsumerAccess.org, number 3030.
This episode is brought to you by Hulu, presenting Paradise. Paradise is Hulu's critically acclaimed addictive drama series, starring Sterling K. Brown, Julianne Nicholson, and James Marsden. The Daily Beast calls Paradise your next TV obsession, and the New York Times says it's exhilarating in all the right ways. Paradise is for your Emmy consideration in all categories, including Outstanding Drama Series. For more information, visit fyc.hulu.com.
Build professional skills this semester with Adobe Creative Cloud and create standout work both in and out of the classroom. Save big on professional creativity tools. Students get 65% off Adobe Creative Cloud, including Photoshop, Illustrator, Premiere Pro, Acrobat Pro, and 20-plus creative apps. No matter what project you're working on, Adobe Creative Cloud apps can help you take it to the next level. Visit adobe.com/student to learn more.
Richard Nixon, Ronald Reagan, George W. Bush, and Donald Trump.
They went after a guy named Roger Stone, who's sitting in the office. And I'll say this in front of Roger, he's no baby. And right now, he's cleaner than anybody in this place. No, they treated him very unfairly.
All of these presidents relied on one man to secure their seat in the Oval Office. That man is Roger Stone.
Roger Stone.
This is the Roger Stone Show, presented by Colonial Metals Group. Now, here's Roger Stone.
And we're back. We're talking to David Schoen, a criminal defense lawyer who has specialized in matters of civil liberties, civil rights, ballot access issues. Without any question, one of the sharpest legal minds in the country. Very ably represented President Donald Trump in one of the two impeachments on the floor of the U.S. Senate. You may remember him when he very famously showed a video of multiple Democrats calling for insurrection. And he joins us now. David, thank you once again for joining the show today. It looks to me like the question of the constitutionality of Jack Smith's appointment as special counsel will never get adjudicated by the U.S. Supreme Court. I had great interest in this because, well, I believed, based on my own experience in the D.C. courts, in which I later learned that the judge in my case withheld exculpatory evidence from my defense attorneys, which would have proved that I had done nothing wrong. I had hoped that those convictions, for which I was fully pardoned, would be revisited in view of the fact that my attorneys believe, and to believe to this day, that Robert Mueller's appointment, like Jack Smith's appointment, was unconstitutional. It was raised by a witness during my trial. The trial judge, of course, denied it. It went to the D.C. Circuit, the most politicized circuit probably in the country, where it was wrongly decided. I'm not a lawyer, but I did learn that expression. It looks to me like it will never be decided, at least not in these cases. Now, the reason this is other reasons this is of interest to me is, as you know, Matt Gaetz, who is an attorney, and is a very able guy. You can tell that in the way he questions witnesses in the hearings at the U.S. House, could now conceivably be appointed a special counsel, which would not require, according to the Biden Justice Department, the confirmation of the U.S. Senate. So President Trump could, even though he is withdrawn his appointment as Attorney General, he could appoint Matt Gaetz as a special counsel to delve into, let's say, the Russian collusion hoax. What say you?
Mm-hmm. That's very, very interesting take on it. Actually, Pam Bondi would be the person as Attorney General appointing him. And you're right. If they would be very hard pressed to argue against it, because they have vociferously argued that there is no requirement for Senate confirmation for the position of special counsel like Jack Smith. And there would be no bar for Matt Gaetz to be appointed. So you're 100% right about that. I would point out that the D.C. Circuit, to the extent they have addressed this issue, has done so in very poor and cursory fashion. There is an article, very important law review article written by Steve Calabrese, Northwestern Law School, University Law School, that fully supports your position on the unconstitutionality of the appointment of the special counsel and, of course, supports Judge Eileen Cannon's position. But you're right, it looks like now it will evade review.
So, David, your reaction to the appointment, first of Pam Bondi. She served very ably here as our state attorney general in my home state of Florida. I know her well, have the highest possible regard for her. She's a woman of enormous courage. And I happen to think she understands that her job is to follow the directives of the chief executive. This is what's going to be different, in my opinion, about this Trump presidency and the previous one. The previous one, while he appointed many good men and women, he also appointed some people who got through the system because they were Republicans, but who really didn't share his agenda. In fact, some of them thought that their job was to dilute, delay, and derail his agenda. I don't see that happening again. Your thoughts on Pam Bondi?
Well, first of all, I think President Trump, as you know very well, is a very trusting person. And he trusted the bona fides of the people he appointed in the past. And many of them really turned not just on him, but on the institution of the presidency, undermined that. And some of them go out and write books and tell-alls and make a lot of money from it. And that becomes a cottage industry. In fact, one of his former lawyers, his own lawyer, I see on the TV all the time saying negative things about him, which I think violates his ethical responsibilities and continuing duties to a client. But anyway, putting that aside, my general comment would be this. The President of the United States has great discretion in choosing his cabinet picks. He can choose them on the criteria that he believes to be appropriate, as he has done in this case. It's true, the Senate confirmation is an important part of the process. Federal 78 talks about it, and so on. But it's the president's prerogative, ultimately, unless there's some disqualifying factor. And I'm not aware of any as to these appointments. Pam Bondi has an excellent reputation. I've spoken to people who worked on the first impeachment with her. Said, first of all, she's a very nice person. But I also am personally aware from the materials that are out there that she has a great sense of the interplay between the criminal justice system and the healthcare system. She's fought very hard against the fentanyl situation, and she should be an excellent choice. But you know these things far better than I do. It's like the varsity asking the freshman team a question. I'm sure your listeners know, there's no person more astute when it comes to political matters and the functioning of the government than you.
Well, that's very kind. You make an important point, though. That is, traditionally, a member of the Senate was only supposed to vote against a president's nominee for the cabinet, if there was some act of malfeasance, some criminal act. You weren't supposed to vote against them just because you didn't agree with their political philosophy. But that seems to be what's at play here. As I said earlier in the show, the idea that any senator would withhold their confirmation from Tulsi Gabbard, who has served her country in combat in both Iraq and Kuwait, was a lieutenant colonel in the U.S. Army Reserve, 4 terms in Congress, serving on the all-important Armed Services and Foreign Affairs Committee. Just because you disagree with her about the future of the Ukraine war, seems to me to be a real corruption of the process. We are unfortunately out of time. Let me thank David Schoen once again for returning. He is a criminal defense attorney par excellence, the man we go to when we want to parse important and complicated legal matters. David, thank you so much for joining us today on the Roger Stone Show. Coming up, folks.
Thank you very much.
Coming up, folks, is Luke Nichter. Luke Nichter is a professor of history at the James H. Kavanaugh Endowed Chair of Presidential Studies at Chapman University, one of the leading authorities on President Richard Nixon, President John F. Kennedy, and we look forward to him in our very next segment. So whatever you do, folks, don't touch that dial.
It's not racist at all. No, not at all. It comes from China.